All right, good afternoon, everyone. I'm Judge Jackie Powell, and we are back on the docket for the afternoon. We are going to begin with the first appearance docket, and for those of you who are here for first appearance today, I am going to make a determination as to whether probable cause exists to detain you, and then we will talk about release conditions. Today's not your trial day, so I would encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. When you come up, I will address everyone individually, and when you come up, if you have an attorney, your attorney will be able to speak on your behalf, and if there's anything that you wish to say, you may want to check with your attorney first before saying anything on the record. All right? We did have some persons from this morning. I don't know if the parties wish to address those first,
Whatever.
or if you're ready to address those, we can address those persons from the morning.
Whatever you want to call Judge is fine with me.
Okay. Why was Manny Simmons reset again? I don't remember.
He said he had got in the family.
Oh, okay,
I think that was that case.
okay. All right. Do we have Manny Simmons in the room? Mr. Simmons was reset from this morning.
Simmons, wake up. Mr. Simmons. He's approaching, Judge.
Okay,
And Judge, just to let you know, while he's approaching, I did have a chance to speak to his family. I believe it was Loudy, and she is expecting your phone call, Judge.
okay.
Hello?
Good afternoon. This is Judge Jackie Powell. I'm calling from First Appearance Court at the Broward Courthouse.
Yes,
May I speak to Lottie McReed?
speaking.
Okay, good afternoon, ma'am.
Good afternoon, Judge.
I have Manny Simmons who's before me this afternoon. How are you related to Mr. Simmons?
I'm his mother.
Okay. And ma'am, Mr. Simmons tells me that there's a death in the family.
Yes,
Who died?
my brother.
Okay. And when is the funeral?
It's going to be, we was trying to get it up for this weekend, but a lot of people couldn't make it, so they changed it to Saturday of next week.
So it's next week.
It's going to be 18th of May at 11.
Okay. And are you planning on posting Mr. Simmons' bond?
I didn't know he had a bond. How much is it? I didn't know he had.
Okay, well, at this time, it's $1,000.
Whoa. Whoa. No, I don't think I'll be posting that one. I
Okay,
don't have $1,000.
okay. All right.
Will he be able to get out for next week, maybe, though? No?
Well, we're trying to this is what we're trying to determine. And so he made that as an issue this morning, and so I needed to verify the situation because he was actually telling us it was this weekend, but
Well, it was supposed to be this weekend. but
Right.
A lot of people couldn't make it. They need traveling time.
I understand. I understand.
Okay.
All right, ma'am. Thank you so much for accepting the phone call.
You're welcome.
Okay, take care.
You too.
Bye.
And Judge, that is exactly what she said, and that's what I told Mr. Simmons then. Speaking with the mother, the funeral was moved to the May 18th. He was unaware of that, and that's what I let him know. But from what he has advised me, Judge, financially, his mom and nor him are in a position to post his monetary bond. So that's why I was asking the court to consider releasing him on pretrial release with the condition of him being randomly drug tested.
Okay. And State, I don't remember. If you could refresh my recollection as to Mr. Simmons priors?
Sure. Possession of PvP last year. He was also arrested last year on a failure to appear. Possession of PvP 2017, cocaine 2013. He was sentenced to 44 months state prison as a habitual offender for grand theft in 09. In 07, possession of cocaine with a VOP, 44 months. Resisting with violence in 04, 35 months as a habitual offender. Delivery of cocaine, possession of cocaine with intent, 2000, 5 years habitual offender. Escape, 98, 20 months state prison. All of his other priors, a combination of cocaine possession or delivery or possession with intent involving cocaine.
Okay. All right, based on what I've heard, I will release Mr. Simmons on level 2 GPS. And, Mr. Simmons, you need to make sure that you comply with, the rules of, pretrial supervision, okay?
Yes, ma'am. Yes, Your Honor.
All right. Oh, it's also, Mr. Simmons, come back, please. It is going to include random drug testing,
Yes, okay.
okay? All right,
Okay.
thank you. All right. And then the other one from this morning is Anthony Lewis.
Four on, Your Honor.
Okay. All right, Mr. Lewis. All right, Mr. Lewis is before the court. Is that because they needed to add the second charge? He's got attempted robbery, no weapon, and then, count 3, battery on a person 65 or older?
To make a long story short, yes.
Okay. All right,
Your Honor, I can advise you, and I can't remember, I think I provided you some paperwork on this case this morning. You set the bond originally on the robbery at 10,000 with the GPS, no contact. I did provide Your Honor with the
I
copy.
did, yes.
Yeah. As you can see in the allegations, it was clear on its face that it was an attempt. I provided the paperwork so you could see the age of the alleged victim, I believe is 67. I was just gonna request that Your Honor keep the $10,000 bond in place with the GPS. And in light of all things considered, I was gonna be requesting a $2,500 bond on
okay,
the ad charge.
okay. All right, so Mr. Lewis, just so you understand, what's going on, there's count 2 is a change of charge, and to attempted robbery, no weapon, and then there's an additional charge, 3, battery on a person 65 years or older, okay? So count 2 is already there, with a $10,000 bond. I am going to leave that in place. And then on count 3, which is the battery on a person over 65, I'll impose a bond of $1,000, okay? And keeping the GPS, yes, all the other conditions, okay? All right, okay, good luck, sir. All right, Velvet Price,
What's prior, Your Honor?
all right, all right, Ms. Price, you are before the court. Count 1 is a petty theft, and count 2 is false ID given to law enforcement, officer, and the court does find probable cause.
I mean, you didn't have any, just wanna make sure you didn't have any concerns, because I do see she's gone through MI on numerous cases in the past. She wants to resolve the offer be time served on both counts.
All right, Ms. Price, do you wish to resolve your case today?
Yes, ma'am.
Okay, and did you hear what the offer was?
What was the offer?
It was adjudication and time served.
Okay.
Do you understand what that means?
No.
Okay. It means that there will be a conviction on your record, but you won't get any more jail time than the time that you've already served.
Okay. That's fine.
Okay? Are you feeling okay, ma'am?
No, I'm just in pain.
Why? Why are you in pain?
My back.
Oh, okay. Is is that going to affect you making any decisions today?
No, ma'am.
All right. So if you want to resolve your case, ma'am, please raise your right hand and I'll ask you some questions. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Price, do you understand everything that's going on here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
And do you need any more time to speak with your attorney?
No, I'm good.
Have you ever been treated for mental or emotional illness?
Yes.
And are you taking any medications, or is there anything about that illness that would prevent you from making an intelligent decision today?
I take medication prescribed by my doctor. Like I suffer from migraines and back and anxiety.
Okay. Well,
And
does that affect you today so that you cannot make a decision about taking a plea?
no, ma'am.
All right. And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Oh, I'm a U.S. citizen.
All right. What plea do you wish to enter, ma'am? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, ma'am, is adjudication and time served. Okay?
Okay.
Good luck.
Yeah.
Oh, Wanda Hope. She bonded.
Come on, step on the edge.
All right, Sarah Gaffney.
No swearing, Your Honor.
Hi, Your Honor.
Hi, Miss Gaffney. Ma'am, ma'am, you are before the court on a misdemeanor KPS for a prostitution charge.
Yes, ma'am.
And your attorney tells me that you wish to resolve your case. Is that correct?
Yes, ma'am.
All right. State, what's the offer?
Offers adjudication, court costs, HIV test.
All right. Ms. Gaffney, if you wish to resolve your case today,
Yes, ma'am.
you will be adjudicated. That means there'll be a conviction on your record. You're going to
Okay.
have to pay the court costs. And then you'll also have to take a HIV test. You don't have to give the result, but you have to show that you did take the test.
Yes, ma'am.
All right. Is that what you wish to do?
Yes, ma'am.
Then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ms. Gaffney, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
Yes, ma'am.
And is there anything about that illness today that would prevent you from making a decision on your case?
No.
And you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Okay.
All right, so what plea do you wish to enter, ma'am?
No contest.
Okay, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served, and that you must take a HIV test, okay?
Thank you, ma'am. Have a nice day.
You too. All right, Mr. Rydell, you're back.
Frequent flyer.
I don't know what's going on today.
I don't know if that's a good thing or a bad thing.
All right, so on page 5, we have Jorge Rodriguez.
He's approaching, Judge. There's your private attorney, Mr. Rydell.
Mr. Rydell, is there something you wish to say before we begin?
Hey, Judge, the first argument I'll make just briefly to PC. In the PC, in the affidavit that I'm reading, the one thing it distinctly states is that this vehicle where narcotics were allegedly found in the trunk, it wasn't my client's vehicle, it was a loader vehicle. So I see the state's probably going forward on a constructive possession argument, but at this point, I would just make the brief argument that there is no probable cause because there's no omission, and it was allegedly narcotics found in a trunk of a vehicle that was not my client's.
Okay.
Just would argue it's the vehicle that he's operating, that he's in control of. He certainly has dominion and control of anything found in that vehicle for probable cause purposes.
All right, so for, probable cause is a low standard, and, Mr. Rodriguez, I'm sure that your attorney is going to file all the necessary motions, but at this time, for probable cause, the court does find probable cause. Does anyone wish to be heard as to bond?
I do, and regarding bonds, Judge, I have no objection to bond being $1,000, and regarding count one, let's talk about count two briefly. This is one of those nuanced, interesting arguments that the legislator kind of punted in this recent legislative cycle. This is a case where just based on theoretical amounts, my client has an astronomical bond to a trafficking offense when the true amounts wouldn't normally dictate this. If this was how the law should have been affected, it would be just a felony amount of synthetic cannabinoid, not necessarily the trafficking amount. But that's not the world we live in. It's the minimum mandatory still does apply with this. I would just ask the court to take that into consideration. Some of the cases we have with synthetic cannabinoids, the charges become so extreme, even though the amounts are not necessarily. So, based on that, Judge, I know my client has a very limited criminal history. He does have ties here. His girlfriend's actually parking right now. She was going to testify to where he's living, ties to the community, and things of that nature. There's not a world we live in that he's going to be able to post a $500,000 bond on this offense to synthetic cannabis. And just based on the amounts, and I understand what the law is, and I understand the amounts Mr. Linder's going to suggest, I'd ask for a $5,000 to $10,000 bond on this, Judge. Just based on the substances that we're looking at, and obviously some of the other issues there. And I know the state attorney's office, and I'm not putting words in Mr. Linder's mouth, there's been some interesting dialogue in terms of, the synthetic front, in terms of how the state attorney in the state of Florida wants to really address that on some of these cases that meet this trafficking threshold, but in reality aren't necessarily at that. So based on that, Judge, I would ask the court to assess a $5,000 to $10,000 bond on count two.
Your Honor, at this point in time, I'm not going to make a request for a specific bond to be set. Your Honor, I'll leave that in the court's discretion. I would ask for a bond higher than $5,000 to $10,000, considering at this point in time, if convicted of this charge, the top count, obviously is what we're all considering, would be a 15-year minimum mandatory prison sentence. I would also note, and I would ask the court to take into consideration the amount of U.S. currency that was found in the vehicle, specifically $6,420. I would note Mr. Rodriguez has a criminal history that out of the state of New Jersey in 2013. He had a weapons offense out of Dade County. I'm showing two priors, and they were in 2013 and 2017. For possession of cannabis with intent to sell or deliver. Also, with the prior in 2013, there was he was convicted of carrying a concealed firearm. I have nothing further, Your Honor.
Okay. All right, the court does find probable cause. As to count one, the standard bond of $1,000 will remain in place. As to count two, the court will impose $20,000 bond. And that'll give him a $21,000 total bond.
Judge, thank you for your time this afternoon.
Okay.
Nice to see you. I
All
won't be
right.
back today.
Thank you.
All right. All right, Mr. Rodriguez, I'll be in touch.
Famous last word.
All right. I'd be happy to do that. Thank you, guys.
All right, Christopher Kohler.
Judge, Mr. Kohler is approaching, and he declined the services of public defender.
All right, Mr. Kohler, you are before the court this afternoon for an aggravated assault with a deadly weapon, domestic violence, and then count two is touch or strike, battery, domestic violence. Okay? The court does find probable cause. And I'll hear from the parties.
And Your Honor, I believe, I've been advised the alleged victim is present and wishes to address the court.
Okay. All right, good afternoon, ma'am. All right, if you'll just stand close enough so we can hear you. Is it your request to address the court this afternoon?
Yes,
Okay, ma'am, then I'm going to have to ask you to raise your hand, and I'll put you under oath. Do you swear or affirm to tell the truth?
yes.
Okay, you can put your hand down, and if you will please state your name for the record.
Chloe Cabral.
What was that? Say it again, please.
Chloe Cabral.
Okay, all right. So, what is it that you wish to let me know?
Just everything that happened last night was, I was basically a victim, and I just got a letter this morning, that I'm gonna lose my apartment for what he did, and I can't lose my apartment. It's like, that's all I have, and I just really need a letter from the courthouse stating that I came here today, and I'm doing everything in my power to keep him away from me, and I don't want him around me ever again, and I just wanna keep my place.
Okay,
Your Honor, if I may.
yes.
Ms. Cabral, and I understand your concerns, and I know you've spoken with our victim advocate, and we'll see what we can do. There's nothing the court can do as far as getting you a letter, but we'll see what our office can do. What I'd like to ask you about, based on the allegations of what occurred, are you in fear for your safety with respect to Mr. Kohler? I need you to say out loud if you are or not.
Yes?
Okay. And if you don't mind me asking, just for the court's edification, has there ever been any previous acts of violence against you by Mr. Kohler?
Yes. He was just arrested 2 months ago for domestic violence
Where was that?
in Boca.
And Your Honor, I don't have any other questions for Ms. Cabral.
Okay. All right, ma'am, you can take a seat. Okay. All right,
Judge, I know that Mr. Kohler has decided to not use the services of the Public Defender's Office, but I think he should know. I spoke with his mom earlier. She put me in touch with the law firm that she's had communications with, and they do not represent Mr. Kohler at this time.
okay. Sir, did you hear that? If you can, turn Mr. Kohler's mic on.
Yes, Your Honor.
Okay, all right, so, you will have to, either retain the attorney or to find another attorney, private counsel to represent you if you don't wish to use the attorneys from the public defender's office.
I'll use the public defender then,
Okay,
if that's all right.
all right, then do you need Mr. Romero, you need a few moments to speak with Mr. Kohler?
Yes, I did, Judge.
I know, it's,
Thank you, Judge, for giving me that opportunity. I'm ready to proceed, Judge.
Okay.
Judge, I just spoke to Mr. Kohler as far as his financial resources are limited at this time. He did tell me the good news is he did manage to get a job. It's for a construction company. He just started, and he hasn't gotten paid yet. Now, he does have family that live in our community. He's going to be reaching out specifically to his mother, who is a school teacher, that's going to be able to assist him and help post a monetary bond. I did advise him that because this is a domestic situation and considering what the victim said, I was quite confident that the court is going to impose a no contact order, and that's something Mr. Kohler knows at this time and will abide by. Judge, what we're asking for the court to consider is a bond somewhere in the neighborhood of $5,000 on count one, somewhere in the neighborhood of $1,000 on count two, about a $6,000 bond on his behalf. We do acknowledge what the victim said and probably the state's concern, so at this time we would have no objection besides a monetary bond, having Mr. Cole being supervised by pretrial release. But we're asking you to consider that monetary bond, which we suggested, Judge.
Your Honor, I'm going to be requesting a $15,000 bond on count one, a $2,500 bond on count two, no victim contact, pretrial release with a GPS monitor. Your Honor, frankly, I don't have confidence that he will just voluntarily follow the court's no contact order. The reason being, I checked, he was arrested earlier this year for domestic violence battery in Palm Beach County. While that case was ongoing, he was then arrested for violating the no contact order in Palm Beach County. Now, it did end up that both cases were dropped, but the mere fact that there was an arrest and a court found probable cause gives me some concern. I can also advise the court he has a criminal history out of the state of Pennsylvania. 2014 theft. He violated their state drug act. 2013 DUI. 2013 violation of their Pennsylvania's drug act. 2012 another DUI in 2012. Theft. 2010. Looks like there was another DUI in 2010. There was he was a, one moment, Judge. Just before he turned the age of 18 and he was adjudicated delinquent, there was a misdemeanor offense involving an allegation of violence. Nothing further at this time.
Okay.
Judge, our last request, Judge, is my understanding is Mr. Kohler does have belongings, personal belongings that he still has at the residence. I would ask the court if he could go one time with law enforcement to retrieve his property. I do understand the victim's concerns, but I'm going to be asking at this time, can he have a third person with law enforcement, not him, to retrieve his property?
Ma'am, you please come up if you wish to address the court again.
There's no property at my house. He just has his truck, which my landlord is going to be getting towed today because she doesn't want it there anymore.
Okay.
Let's go there.
What kind? All right. All right. Based on what the court has heard today and the allegations in the probable cause affidavit, those allegations are that the defendant pulled the alleged victim's hair, grabbed her by the neck, pointed his black handgun at her head, and stated, "Get in the truck or I'll kill you." And then later to pulled her out of the car by her hair. And then today she's before the court. She's testifying that she's fearful of Mr. Kohler. The court has to take all of that into consideration. And so finding probable cause at this time, I am going to impose a $30,000 bond on count one, $2,500 on count two. That is going to involve a level 2 GPS and no victim contact Sir, that means no phone calls, no text messages, no social media, no third party being in touch with her. And based on the testimony of that was heard today, there's no need for you to return to pick up any property. Okay, so I will not, that's not allowed either. Okay? All right.
What'd you do? It's not helping.
All right, good luck. Ma'am, I know you, I think you asked me for a letter, but I can't do that, so,
And Your Honor, just so you know, I spoke with our victim advocate. We're gonna bring her over to our domestic violence unit. Maybe we can offer
Okay.
some assistance there.
all right. Travis Hannah,
Mr. Hannah, come on up, please.
Mr. Hannah is before the court. Count 1 is domestic battery by strangulation. Count 2 is false imprisonment. Count 3 is touch or strike battery domestic violence. Count 4 is DUI alcohol or drugs. And count 5 is an open container. That's not for magistrate. The court does find probable cause. All right, and I'll hear from the parties.
Your Honor, I'm gonna be requesting a $20,000 bond, I'm sorry, $25,000 bond on count 1, $5,000 bond on count 2, $2,500 bond on count 3, pretrial release with a GPS monitor, no victim contact. This is based on the level of violence alleged in this case, but I would also note Mr. Hannah's history of violence. In 2017, he had an exposure of sexual organs. He violated his probation as recently as January of this year. 2017, he was arrested for 2 counts of domestic violence battery against a different alleged victim. Those charges were dropped. 2011, strong-arm robbery. He violated probation, was sentenced to 61 months state prison. 2010, armed burglary of a dwelling, grand theft of a firearm, and grand theft. Violation of probation, 61 months state prison. 2010, he was convicted of felony battery, domestic violence by strangulation, and tampering with a witness or victim, and this involved a different alleged victim. He violated probation, was sentenced to 5 years in state prison. 2010, he received 2 withholds on 2 counts. He received withholds on 2 counts of a simple battery. Nothing further, Judge.
Judge, $32,500 is something that Mr. Hannah is not going to be able to afford. Judge, he just started working at a brand new job. It's a pool company where he just started approximately 3 weeks ago, where his total, I guess, salary per week is approximately $300. He's been here his whole entire life. He's 27 years old. He lives with his grandfather. His grandfather's helping him out until he gets on his feet. Unfortunately, this new job was leading him there. Judge, right now, he's going to be depending on his grandfather to help post his monetary bond, but he's elderly and on fixed income. So, Judge, that is the reason why we're asking for a $3,000 bond on count 1, $1,000 bond on count 2, $1,000 bond on count 3. So the defense is asking at this time for a total of $5,000 on Mr. Hannah's behalf.
All right, the court finds probable cause. Count 1, the bond is going to be $10,000. Count 2, $5,000. Count 3, $2,500. no victim contact, and that's also going to include level 2 GPS.
Judge, also, would you sign a photo order as well?
Sure. Okay. Michael Anderson.
Mr. Anderson, come on up, please. He's approaching, Judge.
All right, Mr. Anderson, you are before the court on a misdemeanor KPS matter for possession of drug paraphernalia. The court does find probable cause. Sir, what do you wish to do today?
I'd like to get it resolved if it's possible.
Okay, sir. If you wish to resolve the case today, it'll be adjudication and time served. Do you wish to accept that offer?
Yes, ma'am.
Okay, Mr. Anderson, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Anderson, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Or do you need time to speak with an attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you do have the right to a trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
That was 1980s, though.
Okay. And is there anything about that that would not make you, that would affect you making a decision today?
No, ma'am.
Okay. And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, then, Mr. Anderson, what plea do you wish to enter? Guilty or no contest?
I would like to go with no content.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Okay?
Yes, ma'am.
All right, good luck.
Thank you.
Jason Pierre.
He's here, present.
All right, Mr. Pierre, you have 3 misdemeanor capias on a charge of possession of cannabis, a petty theft, and then the third, which is a municipal ordinance violation, is a possession of controlled substance. Okay? And the court does find probable cause, and Mr. Pierre does have court tomorrow.
Judge, Mr. Pierre wishes to try and resolve this matter today.
Okay?
States offer you withhold court costs on 1 and 2.
Okay?
He wishes to accept the state's offer, Judge.
All right, it'll be the same sentence on count 3.
He's ready to proceed, Judge.
Okay, Mr. Pierre, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Pierre, do you need any more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Then, Mr. Pierre, what plea do you wish to enter?
No contest.
I accept your no contest plea. find that it's freely and voluntarily given. Your sentence serves withhold adjudication and court costs on all 3 counts running concurrent, okay? Joseph Olaya,
Mr. Olaya is here, present, Judge.
Mr. Olaya is before the court. He has 2 counts. Counts 1 and 2 are burglary, unoccupied conveyance unarmed, and count 3 is a petty theft charge. And the court does find probable cause as to those counts.
Judge, in regard to the probable cause,
Yes.
count 2, the second vehicle that was broken into, there does not appear to be enough here in this probable cause affidavit to conclude that Mr. Olea was the person who broke into that car. I think all the evidence is very thin and circumstantial, that he broke into one car in one area, but there's no evidence connecting him to the break-in of the second car.
That's fine, Your Honor.
Okay, I'll find no probable cause for this count 2. And, so we have counts 1 and 3. Here is the bond. Oh.
Your Honor, I'm going to be requesting a $5,000 bond on count 1. I would note that this situation began when the witness saw Mr. Olaya pulling on 2 other car door handles. He was unable to enter those vehicles because they were locked until he was then able to successfully enter, unlawfully enter the vehicle that makes up the allegations for count 1. I would note, I don't have anything further, Your Honor.
Okay.
Judge, we're going to be asking for the court to consider releasing Mr. Olaya on pretrial release. At this time, he's not working. He basically is helping to take care of his father who lives in Tamarack. His father recently suffered a stroke and he is on disability, and that's how they basically managed to live with his financial resources. Right now, he doesn't have his father's phone number memorized. He does have his phone and property, so we're going to be asking for a phone order, but he doesn't know if his father will be able to afford to post a bond, and that's why we're asking for pretrial release on this third-degree felony, Judge.
All right, the court finds probable cause on count 1. I am going to impose a $2,500 bond. And then the count 3, the bond is $25. Okay?
And phone order, Judge?
Yes.
Thank you, Judge.
Ryan Lou Young.
Judge, he bonded.
Okay?
Mr. Amaya?
Yes, Sebastian Amaya.
He's approaching, Judge. He's our main.
All right, Mr. Amaya is before the court. Count 1 is for driving with a suspended or revoked license. Count 2 is felony violation of community control. Count 3 is the same, violation of community control. 4, 5, and 6, no, 4 and 5 are violation of felony probation. Those have no bond holds, as well as counts 2 and 3, no bond holds. And count 6 is possession of cannabis 20 grams or less, and the court does find probable cause. Mr. Amaya's bond on count 1 is $100, and counts 2 through 5, he has a no bond holds, and he does go to court on tomorrow at 8:30 before his division judge. Okay? Fernando de Bear.
Your Honor, I've been advised that there's a Portuguese interpreter on the way.
Okay, so we need a Portuguese interpreter.
He does speak some English, but to be on the safe side, I believe we should have one present.
Is one on the way, have been ordered?
Yes, they're doing the paperwork right now, and they're sending one.
All right, we'll save that till the end or until the interpreter gets here. Brandon May Ryder.
He's here, present. He's approaching. Come on up, sir. And Judge, he is proceeding pro se.
All right. All right, Mr. May Ryder, you are before the court for one count of burglary, unoccupied conveyance, unarmed. The court does find probable cause, and we need to discuss setting your release conditions.
Okay.
Is there something you wish to say in regards to setting your bond? Do not talk about the case.
I don't know if he knows that you're asking him.
I don't know what to say. I didn't.
Your Honor, if you
All
want
right.
me to begin.
I was nowhere near there.
All right, I'll hear from the state.
Your Honor, I'm requesting a $7,500 bond, and the reason being, one, it appears to me that Mr. May Ryder has no ties to the community. He has a warrant out of the state of Michigan, where he's from, for a failure to appear in an aggravated assault, and that warrant was just issued April 9th of this year. I'm showing that assault dates back to December of last year. He does have prior arrests, though, in the state of Florida. Those date back to 2016. Going from 2010 to 2016. St. Lucie. Just trying to see anywhere else. No, just St. Lucie County.
Okay. All right, Mr. May Ryder, the court's going to impose a $5,000 bond on this charge. Okay? Good luck, sir. Anthony Lewis?
I think, Your Honor,
We did Mr. Lewis, right?
yes.
Oh, did I have extra? Or
That was
that was
the
a
problem
reset
this
from
morning.
this morning? Okay. Yeah, because we had that handwritten one. All right, on the, let's go to the felony hearing docket. And we have Ricardo Gonzalez Guerra.
I think he was
He
released,
posted-
Judge.
He
Okay.
posted bond.
Elena Prober. All right.
It's
What's
a
the,
motion, oh, I'm sorry.
what's the status? Is it a ROR?
It's a motion to release, Your Honor. The state did file an information today. We filed the top count of grand theft.
All right, ma'am, you were brought before the court on a 30-day motion, but the state has informed me that they've proceeded with filing the formal information as to the grand theft charge. So there's no action for the court to take today, okay?
Okay.
All
Judge,
right.
she's awaiting a program, I believe. Is that right, Ms. Prober?
Yes,
I don't know if the court would consider, what program are you waiting for?
stepping stones.
I mean, was it court ordered?
Yes.
Well,
Oh, who ordered it?
Judge Cal Evans, and they had a bed available immediately.
So,
one moment, Your Honor, let me.
how much is their bond?
It's gonna be 1,000. I'm just checking to see.
Her total bond is $2,000.
No, Judge Evans might have done that on a VOP. He didn't order it on this case.
Oh, okay. Okay, all right. All right, ma'am. So the information is filed as to the grand theft charge on this case, okay?
Okay.
I'll
Dale-
try and get you into court as soon as I can, Ms. Prober, to maybe get you over to Stepping Stones as soon as we can, okay?
Okay. Thank you.
All right, Dalen Garin,
Conti, Your Honor.
Interpreter.
all right. What's the status of Mr. Garin's case?
Your Honor, we've now filed an information. Mr. Guerin is entitled to an ROR. If he chooses to accept the ROR, Your Honor, the only thing I'd ask is if you could advise him that the no victim contact order is still in place. From what I can tell, there is still an immigration hold.
He's got an immigration hold.
Okay, so then do we want to proceed with the granting the ROR?
I don't think so, Judge, because he's not going anywhere.
Your Honor,
Yes, sir.
if you do give me the R&R, my immigration hold gets lifted.
Oh, okay. All right.
All right, sir, so, you are entitled to this, release on your own recognizance because the state has not formally filed the charges, so I will sign the order granting the ROR today on this case, okay?
All right, ma'am. Thank you very much.
All right. We have the Portuguese interpreter. We have the Portuguese interpreter, so Fernando de Beer.
Come on up, sir. He's approaching, Judge.
All right, Madam Interpreter, can you please raise your right hand? Do you swear or affirm to translate from Portuguese to English and English to Portuguese? And can you please state your name for the record?
Jefremovas, Jefremovas.
Okay, Ms. Mulvas, thank you for being here. Mr. De Beer,
Senhor de Barre,
you are before the court today
o senhor está perante a corte hoje
for one count
por uma acusação
of premeditated murder.
de morte premeditada.
The court does find probable cause,
A corte julga haver causa provável
and at this time, I will hear from the attorneys.
e agora os advogados vão falar.
Thank you, Your Honor.
Obrigada, Vossa Excelência.
In light of the fact that Mr. De Beer has been arrested for a capital offense,
Ok? Devido ao fato que o senhor de Barre foi preso por uma ofensa capital,
the state would be seeking a no bond hold
o Estado vai procurar que não receba fiança,
upon a finding of proof evident or presumption great for first appearance purposes only. Upon a finding of proof evident or presumption great
ok? Se encontrarmos evidência maior
for first appearance purposes only,
para o objetivo de primeira aparição apenas,
the state would be relying upon the probable cause affidavit
o Estado vai basear-se no comprovante de causa provável,
prepared and provided to the court by
preparado e entregue à corte por
Plantation Police Department Detective
pelo detetive do Departamento de Polícia de Plantation,
Santo Nestazo.
Santos Nastazo.
Nothing further, Judge.
Sem mais, senhora juíza.
We will leave Mr. DeBear. We will leave Mr. DeBear
Nós vamos deixar o senhor De Beer
to discuss his bond situation
para discutir a situação da sua fiança
in front of his division judge
perante o juiz da sua divisão
at another time.
em outra data.
At this time, however,
Neste momento, no entanto,
we would be invoking Mr. DeBear's Fifth Amendment rights.
neste momento vamos invocar o direito do quinto amendment do senhor De Beer.
We would put
Da
this,
emenda.
we would put the state and police
A polícia e o Estado vão ser postos
on notice
sobre aviso
that they are not to attempt
que eles não devem tentar
to contact Mr. DeBear
contar o senhor De Beer
or to speak with him in any way
ou falar com ele de qualquer maneira,
without first contacting
sem primeiro contatar
his attorney.
o advogado dele.
I'm advising you, Mr. DeBear,
Eu estou lhe informando, senhor De Beer,
do not discuss this case with anyone.
não discuta esse caso com qualquer pessoa.
Don't talk to anyone in the jail about this case.
Não fale com qualquer pessoa na prisão a respeito desse caso.
Do not discuss it on the telephone.
Não discuta a esse respeito por telefone.
Everything you say on the phone is being recorded,
Tudo que o senhor disser por telefone está sendo gravado.
and whatever you say will be used against you later.
E tudo que o senhor disser vai ser usado contra o senhor em uma data futura.
Do you understand, sir?
O senhor entende?
Yes.
Yes.
Okay, based on the allegations in the probable cause affidavit,
Com base nas alegações e o affidavit de causa provável,
where it is reported
onde foi reportado
that the neighbors were told by Mr. DeBear
que os vizinhos foram informados pelo senhor De Beer
that he had killed his wife,
que ele tinha matado a sua esposa,
and then the report further stating that his wife was found dead.
e o relatório falou também que a sua esposa havia sido encontrada morta,
As he had reported to the neighbors.
conforme ele havia relatado aos vizinhos.
The court does find probable cause,
A corte encontra haver causa provável
and then the court makes a preliminary finding
e a corte faz, então, essa descoberta preliminar
of proof evident presumption great,
de... I'm sorry, Ana?
proof evident presumption great.
Prova, presunção maior.
And this is without prejudice
E isso é sem prejuízo
for the defendant to have a hearing
para que o réu tenha uma audiência
before his division judge
perante o juiz da sua divisão,
based on
com base em
State v. Arthur.
Estado v. Arthur.
And the court will hold Mr. DeBear
E a corte vai reter o senhor De Beer
no bond
sem fiança
at this time.
nesse momento.
Okay? Okay, sir. Thank you. Thank you.
Yes, Your Honor. It's all for the interpreter. Thank you. May I have a signature?
Okay, we will continue on the hearing docket. Dana Myers. on the felony hearing docket.
See Paul Ryan?
All right,
Your Honor,
yes,
it's a motion to release. We've downfiled it to a misdemeanor. I don't have an objection to an ROR. If Mr. Reedy is inclined to prepare, under the new case number? Oh, you're the best. Then, yeah, I have no objection to the court signing an order RORing her on the new misdemeanor case that's been created upon the downfiling.
okay. So, ma'am, I will sign the order granting your release on your own recognizance, and just so you know, if you haven't heard, that the charge has been downfiled to a misdemeanor. So the filed charge is a misdemeanor charge, okay?
Yes, ma'am.
All right, good luck. Courtney Chapman,
Release on my own recognizance.
She's here, present, Judge at Main, approaching.
all right, Ms. Chapman is before the court for a second look on her bond amount.
You're on a ROR to pretrial with a GPS level.
I
2.
did?
Yes, you did.
So what's the issue now?
Guessing they have no.
I believe Ms. Chapman gave pretrial, two potential addresses, one of her friend Rachel, who resides in Fort Lauderdale, and another friend Shakira, who resides in West Palm Beach. So Ms. Chapman is waiting to see if what's the news.
Okay,
She actually told us she was homeless. She couldn't provide them with the names or numbers to people. So they have to send out the field team to the addresses that she provided.
okay. All right, so it's in the works because she didn't have the names or the what?
Or phone numbers for us.
Or phone numbers, so they have to physically go out to the addresses to find the people. Okay, Robert Fodden,
He's approaching, Judge.
okay. All right, what's the,
Just second
Judge,
look with the
he's here on a $1,000 bond on a grand theft. I asked the court if you would consider releasing him on pretrial release. I believe the court was in disagreement, Judge, and we're asking again.
So, Your Honor, this is a grand theft where he went into the victim's business. The victim left his cell phone sitting on the countertop besides the tip jar while he was cooking something. Apparently, Mr. Fodden took the phone and left the business, stealing the business owner's phone. He has a history, I believe. I know what my concern with setting him ROR to pretrial was. He has a history of failing to appear in court and violating probation, and just it's a pattern of an inability to follow conditions given by the court to follow.
all right, I reviewed the probable cause affidavit again, and, at this time, I'm going to leave the bond in place at $1,000. Okay, Daryl Wilcher,
I believe he posted bond.
okay. And then Willie Richardson,
North Broward, Your Honor.
This is a second look on a grand theft auto. I believe the court's concern was his history. As far as Broward, going back to 03, a possession of cocaine with a VOP, 96 months in Florida State Prison. 04, felony battery, great bodily harm, 96 months state prison as a habitual offender, and a prison releasee reoffender. Theft 04, possession of cocaine 03, 96 months. 03, another cocaine, 96 months. 99, possession of cocaine, 18 months. 94, possession of cocaine, a year and a day. He's gone to prison for strong arm robbery, robbery with a firearm or deadly weapon. That's Mr. Richardson's Broward history.
from what Mr. Richardson tells me, Judge, he has the money in his wallet, but his wallet is in a place where he can't get to it. It's not in his property. I'm going to try calling his wife, who he does not live with, to see if, one, if he can live with her, and two, if she can somehow get a hold of his wallet and allow him to post bond. But I think both of those things might be a little, hopeful, and maybe overly optimistic. So I'd ask the court to consider releasing him on pretrial release, Judge. As you can see, he's in a wheelchair. He does have physical problems, and I don't know that he's going to be able to come up with this kind of money.
Why is he, do we know why he's wheelchair bound?
2 strokes and 6 heart attacks, ma'am.
And he's charged with grand theft auto. So, what is the,
I can still stand. I can still drive, ma'am, but my walking long distance is very limited. I have COPD. I have a bunch of health problems, which I take a bunch of meds for. But, ma'am, I'm not saying that I've laid down by any means with life. This is just something unfortunate between me and my son-in-law.
Don't discuss the facts of the case, Mr. Richardson.
Yes, sir. I mean, it's just,
Don't discuss the
I'm
facts of the
trying,
case.
ma'am.
Don't means
I
don't.
really need to be, would like to be released, retrial or.
okay, at this time, the court will, release Mr. Richardson to level 2 pretrial supervision. Okay?
Thank you, Judge.
All right, Drapier Johnson.
Judge, he was here before you, I believe, a couple of days ago. We didn't ask anything because he came here, he was being held no bond. The good news is he appeared before his division judge, I believe, on a felony offense. He was granted pretrial. The only thing holding him up is this misdemeanor drug paraphernalia. I'm asking if the court would consider an ROR on Mr. Drapier's behalf so he can go to work. He worked at Bocan where he's a cook, and that's what we were just talking about.
Did we verify he's on pretrial?
Yes.
Okay, so then I'll ROR him on this count.
Thank you, Judge.
All right. Okay. Do we have anything else? All right. Well, thank you, everyone. Have a good, yes? Mr. Who?
No,
There's
no
no
action.
change, no, yes. All right.